So hold on a second. This is an Act of Parliament from 1939 called the Cancer Act.
The Cancer Act.
And that means that even if you had a proven natural remedy, a natural cure, if you like,
you're not allowed to sell it or promote it.
You can't even tell people about it.
You can't tell it.
Two of the large supermarket chains in the UK have been prosecuted under that very act by taking information from the Department of Health about particular fruits and vegetables, using exactly the terminology that is used by the Department of Health about you should consume at least 5 portions of fruit and vegetables a day to lower your risk of heart disease and cancer. And they placed these up around the areas that they were selling fruits and vegetables, and they were prosecuted because they were referring to it's okay to do it generically for education, but of course as soon as the apples and oranges, to take some examples, and the cauliflowers and cabbages are sold in a particular supermarket, they are those products belonging to that particular brand of supermarket. So they become products, and so under that same act it became possible for those supermarkets to put out what could be regarded as very important educational information to the consumer.
So it's illegal to say that, well, it's legal to say that, for instance, a particular kind of fruit is good for you and prevents disease.
Correct.
But if you put that next to a pile of those fruits, that's illegal.
That's right. You know, in order to try and clarify
I'm
this...
just trying to get my head around that.
Exactly.
They're doing everything they can to really help us, aren't they?
Exactly. So as soon as it becomes the fruit as a product, or you are selling a juice that has got that fruit in it, if there is a medicinal claim, which means that the product is used to assist, support, correct a particular disease or disorder, you immediately come under medicinal law.
But what about all this subtle advertising where you've got some yellow fat products, and I'm not going to name any names, that have a picture of a heart shape on the box, and there's some breakfast cereals that mention your heart as well.
Yes, the bottom line is that there are some very large corporations in the world who spent a lot of money on clinical trials with both the yellow stuff and the crunchy stuff in cereal boxes, adding particular compounds such as phytosterols that lower cholesterol. And what has happened is that to create this if you like, this carve-out within food law and outside of medicinal law, they've developed an EU-wide regulation called the Nutrition and Health Claims Regulation that has a particular section for products that can be used for disease risk reduction.
Are these like nutraceuticals, are they?
Well, they can be nutraceuticals, or they can be functional foods, or they can be whole foods, but they're for particular products rather than being generic foods or generic ingredients. So far, there's only one company that has been able to meet the almost drug-like requirements in terms of trials. There are companies who've attempted to go through with 30 clinical trials that have been rejected, and they have to go through the European Food Safety Authority. And one of the reasons why this particular yellow stuff is able to make claims till the cows come home is because they have one of these...
Although not many cows come home and it's manufactured, do they?
But if you look at it, the other side of it, for people who are selling, say, a nutraceutical product that has the phytosterol in it, that has a particular amount that has been shown to lower cholesterol, and of course that is the disease risk that is being dealt with in the case of these yellow spreads. And it doesn't have the nasty carrier, which is the yellow stuff. And you know exactly how many of these capsules you're going to have a day, because you don't actually know how many slices of bread you're going to have, and you don't know how thick your yellow paste is going to be on the top of it. But so you have a measurable amount. Because those companies haven't got the resources to put that product through, they will never be able to get the claim. So if you like, it's a passport system for big business.
So, but on my
case... sorry to interrupt you there, Dawn.
Yeah.
So, Robert, just to get to that point then, what you're saying is there are some companies that manage to do it, can do it, and because they're big enough.
There is one of the general trends in global regulation of foods and nutraceuticals and natural products is that the bar is rising all the time, to the point that many of the smaller players, and Dounne's company is one example, they can't play the game. They have developed a particular directive for traditional herbal medicinal products. And Dounne might struggle to meet some of the requirements there. Some of the eligibility requirements require that that product needs to have been sold for 30 years. Dounne, have you sold the product for 30 years?
15.
Okay, so
We're halfway there. But then by the time you get to 30, it'll suddenly become 45 years.
This is it.
So she can't, she's not eligible under the fast-track licensing system for traditional herbal medicinal products. A separate issue is while this system has been developed specifically for some of the great healthcare traditions such as Chinese medicine and Ayurveda, there is not a single classical medicine out of the Indian or Chinese traditions that has gone through, because the particular technical requirements, let alone the costs, are so difficult that actually complex herbal mixtures don't go through that particular door.
So how are all these Chinese medicine shops in shopping centres that have sprung up, how are they able to operate?
They have been running basically as herbal food supplements for all this time. When the transition measures for this particular traditional herbal medicinal products directive come to an end on the 31st of March 2011, there is going to be major problems.
So they'll all go out of business, because at the moment they've got signs in their windows saying, you know, a list of diseases, basically. And kind of hinting that that list of diseases and their products are in some way interrelated.
Yeah, there is no doubt that under existing laws, some of them are able to, you know, find themselves in trouble, and some of them are already being prosecuted. The other side of it is that some of them are actually very responsible, meeting the laws completely, but those laws will change dramatically in 2011 when the transition phase of this traditional herbal medicinal products directive comes to an end.
So that means that even places like health food stores, which don't say much about their products now, do they, are going to be able to say even less. Will you still be able to buy these things?
You will be able to buy a much smaller range. There is, at the moment, a grave risk that many products will fall between two stools, between the botanicals food supplement stool and the licensed traditional herbal medicinal product stool. At the moment, of the little over 20 products that have licenses, what is going to happen to the thousands that are currently sold as traditional herbal products now? And if you look at the fact that there are traditions that have been around for thousands of years, if it's not possible to even meet the data requirements, we're working with companies in India and China looking at where the European regulatory model, which has been largely translocated out of a drug model, where it breaks down. And it's like trying to put a square peg into a round hole.